Overhaul of Supreme Court ethics runs into GOP opposition. I thought this was a little bit interesting. Senate Democrats promised on Tuesday to pursue stronger ethics rules for the Supreme Court in the wake of reports that Justice Clarence Thomas participated in luxury vacations and a real estate deal with a top GOP donor. Republicans made clear they strongly oppose the effort. It's a great piece of tech, but as all tech can be used for bad purpose, should still be used regardless if you want. You put them in the expensive sound and equipment and lighting. Just realise that tech has upsides and downsides, but be very careful with what you do. Hard to stay up to date with everything. Can make one for about $1.25, 15 minutes to assemble, so 20 minutes to program. Tech is out. Who wants it? Anyone who wants it bad enough can make it. Senator Dick Durbin, the Democratic chair of the Senate Judiciary Committee, said lax ethical standards have created a lack of public confidence in the nation's highest court. Pot? Kettle? So politicians get all these perks, all these donations, all these backhanded deals, all that sort of stuff, and all of a sudden they're concerned because there's a possibility that some judges might be receiving some beneficial treatment as well. Don't get me wrong, I don't think that they should be, but I don't think politicians should be either. Lol, it's because SCOTUS is striking down all the left's bullshit. Stalking is a crime. Start documenting everything you think you're being stalked, even if you're not sure, just in case you need it. Be careful and situationally aware. It's good advice. The Supreme Court could step up and fix this themselves, Durbin said as he opened the hearing. For years they have refused, and before the court will not act, Congress must. Because the court will not act, Congress must. Republicans criticised the hearing in it as an effort to destroy the reputation of Thomas, one of the staunchest conservative voices on the court. The comments showed how unlikely it is that Congress will pass legislation on the matter, with the parties' worlds apart when it comes to credibility of the Supreme Court, particularly after the seismic decision last June that overturned abortion rights. Democrats called the hearing after news reports detailed a close relationship between Thomas and a conservative donor from Texas. The donor, Dallas billionaire Harlan Crow, purchased 3 properties belonging to Thomas and his family in a transaction worth more than $100,000 that Thomas never disclosed, according to a non-profit investigative journalist operation ProPublica. Purchased 3 properties worth... So someone bought his house and he never disclosed it. Like, I get that the guy's a donor, but... That sounds like a bit of bullshit to me. Organisation also revealed that Crow gifted Thomas and his wife, Ginny, with hundreds of thousands of dollars worth of annual vacations and trips over several decades. Look, that's a little bit more on the iffy side, but this was after he was appointed, yeah. Durbin invited Chief Justice John Roberts to testify at Tuesday's hearing, but he declined, saying that testimony by a Chief Justice is exceedingly rare because of the importance of preserving judicial independence. Roberts also provided a statement on ethical principles and practices signed by all 9 justices that describes the ethical rules they follow about travel, gifts, and outside income. While the rules are not new, the statement provided by Roberts said that the undersigned justices today reaffirm and restate foundational ethical principles and practices to which they subscribe in carrying out their responsibilities as members of the Supreme Court of the United States. Instead of Roberts, senators heard testimony from 5 legal and ethical experts, including a former Attorney General, Michael Mukasey, who served under President George W. Bush. He said recent criticism of High Court justices is without merit. Jeremy Fogel, a federal judge for 20 years who is now retired, said he was not at the hearing to criticise any justice or participate in a political debate. He expressed his fears about eroding public confidence in the Supreme Court, fueled in part by increasingly contentious confirmation processes for justices and the spread of disinformation on social media. A lack of clarity about the justices' ethical obligations, Fogel said, only feeds the perception that the justices are deciding cases based on political preferences rather than the law. Oh, bullshit. He went on vacation. How dare he? Thomas hasn't done anything wrong. Should audit everyone in all 3 branches of government. That'd be nice. With drug testing would also be good. Thomas is married to a white woman. The Dems don't like that. He's on the wrong side. Fogel said he agreed with Roberts' explanation for how the Supreme Court is different from other federal courts and why it would be inappropriate to simply adopt the code of conduct applicable to all other federal judges. But that doesn't mean the court should have no formal code at all. That it couldn't adopt a modified code that accounts for these differences. Cedric Payne, a senior director of ethics at the Campaign Legal Center, argued in favour of a stronger ethics framework. He said the Supreme Court lacks a formal recusal process and a binding code of conduct, amongst other things. Interesting. Okay. The Centre advocates for every American's right to participate in the democratic process. There is no room to debate that the Supreme Court has the weakest ethics rules in the federal government. Mukasey? I don't know. Defended Thomas in his testimony. He noted that Thomas said he consulted others, including colleagues, about whether to include trips on his financial disclosure form, but was told that an exemption applied for hospitality from friends. Last month, when the federal judiciary bolstered disclosure requirements for all judges, Thomas said that he will be guided by it and include such travel and vacation accommodations in future reports. He said he also said the purchase of Thomas's childhood home represented a loss to Thomas. He was obligated to report it, but did not do so because he mistakenly believed that he didn't have to report a transaction in which he sustained a loss. He noted that Thomas said he intends to amend his financial disclosure for the relevant period. In the wake of the reports about Thomas, Democrats in both chambers are pursuing legislation that would create a process for investigating misconduct at the Supreme Court and strengthen recusal standards and disclosure of travel and hospitality. They're also pursuing changes through the spending bill process, calling on lawmakers to direct the Supreme Court to adopt binding and enforceable ethics rules. Senator Sheldon Whitehouse, who is leading the legislative efforts, said the court has conclusively proven that it cannot police itself. I'm sorry, but all this is just fucking hypocritical. Thomas is also a staunch constitutionalist, so that pisses them off. If you ever need a laugh, watch Biden's questioning during Thomas's confirmation hearing. Okay. Well, I mean, I'm just about done with the news, and we've got, 15 minutes to kill. How long's is there like a cut down? Who did Thomas piss off to warrant them leaking the info? Pretty much any Democrat, I would assume. Maybe just look at themselves first, Nancy Pelosi, for example. Let's have a look. The United States is not a democracy, it's a republic. What's this? Excuse me. Alright, so there's 6-minute rant by Biden. Let's have a look.
Just one notion here, Judge, if I may. Hopefully attempt to put it to rest. One, do not count me as one of your detractors
Holy
because
crap,
I
even he
ask
didn't have
you
hair.
tough questions. Number two, the issue of natural law may confound the people, to use Senator Simpson's phrase, but not a single legal scholar in America. And I hope you meet that test, or you shouldn't be on the Supreme Court. You must have a knowledge and insight to
Hard R coming fast and hard. As long as it's Joe Biden that says it, I don't have an issue.
the Constitution that is better than the average lawyer. And I'm sure you do. That's why I'm sure you understand what I'm about to say. Not a single legal scholar in America fails to understand the significance of whether and if how one applies natural law.
I'm sorry, what the fuck did you just say? I get that it's like 7 in the morning and I'm half asleep, but whether and if natural law applies. And you're saying that even back then he might have had some.
Judge Bork devoted a chapter in his book about how those people who want to apply natural law are bad. Not bad in a moral sense, are wrong. There's an entire school of thought that you are fully familiar with. I'm not failing to accept your answers yesterday. I just want to make sure we all know what we're talking about here, that you and I know at least what we're talking about here. There's not a single legal scholar who does not understand that there's a fervent, bright, and aggressive school of thought that wishes to see natural law further inform the Constitution than it does now, argued against by the positivist led by Judge Bork. Now again, that may be lost on all the people. You know and I know what we're talking about. Now, all I'm out to do in my second round, and others are, is to find out whether you, in fact, do apply natural law, and if you do, how. You answered that partially yesterday. I'm somewhat confused. I'll come back to it. But
Hang on. Where is... Oh, it's right in front of me. Of course it is. A, B, C, D, E, F, G, H, I, J, K, L, M, N... Natural justice, natural death, natural consequence, natural rights, natural servitude. Biden is confused. No. What the fuck is he saying? Tireless school of thought that I don't belong to. Okay. Let me just... I want to get the proper definition of this because I don't want to fuck it up. Natural law is the system of law based on the close observation of human nature and based on values intrinsic to human nature that can be deduced and applied independently of positive law. In simple terms, natural law maintains that there are rules of right and wrong that are inherent in people and are not created for society or... not created by society or court judges. Basically what he's saying is he wants to know whether or not Clarence Thomas would apply extrinsic factors when interpreting the law, whether he would apply societal values when interpreting and ruling on cases. Which is exactly the opposite of what a judge is supposed to do anyway. Because they're supposed to look at precedent, they're supposed to look at how the legislation is drafted, they're supposed to look at the case law and the arguments put before them. No, not specifically morals. More It's slightly more in-depth than morals. It's more, for lack of a better term, it's keeping the pulse on society and then taking it into account when making a judgment.
Let the record know, for all the press to know, whether someone applies natural law is of phenomenal significance. And there's not a single legal scholar in America you can question who will not tell you that is not true. Now, you may apply it, someone may apply it in a way, like Moore, who leads him in a direction that is, quote, liberal. You may apply it in a way that leads you in a direction that's conservative. Or you may, like many argue, not apply it at all. But it is a fundamental question that is going to be almost impossible for non-lawyers to grasp in an exchange. But you know and I know it is a big, big deal. And in conclusion, the only reason most of us I asked you about natural law is that is how you gained your reputation, right?
Basically, it's the argument between whether or not law, when you're applying it, should be subjective or objective. I mean, the law itself should be fairly sterile when it comes to actually making a determination as a judge, because you're supposed to be impartial. Biden's basically saying in a roundabout way, you can understand this, Hayden, was this school of what the fuck, where you learned how to understand this giant pile of cow shit. No, it's more I learnt about it in law school, because it's like I can understand how the everyday person may not actually follow this, and to be perfectly honest, I could be talking out my ass because our version of natural law could be entirely different to how Biden understands it, which, you know, is altogether possible, because fuck knows what's going on in that guy's head, let alone back then. Basically, what he's trying to say in a roundabout way is, are you going to be biased and make certain judicial decisions and interpret legislation in a way that leans towards conservative values? He's basically taking a pot shot at him.
Rightly or wrongly. When you are spoken about by other lawyers, when you are spoken about in the press, I didn't invent it. You are spoken about in terms of your speeches on natural law. Now, I accept for the moment that everybody misunderstood you. Well, not everybody. Let me be precise. That they were just philosophic musings. I accept that for the moment. But I don't want any senator to think that, quote, your detractors are out there searching for a theory that doesn't have significance. Yeah,
just to clarify, natural justice and natural law are different. And that may be something that I may need to discuss at some point as well.
I, like Senator Simpson, didn't do well in law school. Probably worse than Senator Simpson. No, I did very poorly in law school. I did very poorly in law school. But I spent an awful lot of time since law school dealing with this subject. And I know it. And you know and I know what a judge's view on this issue is of phenomenal consequence to the future of this country. And again, if your view is, stated view, and I'm needed explored further, is, Senator, whenever I speak of natural law, there are philosophic musings, they in no way impact upon my view in the court, fine. That answers the question. That answers the question. But please let no one misunderstand. This question informs every other application of the law in the Constitution. It's that basic, it's that simple. I accept your assertion that it doesn't for you. I accept that. I want to go back and discuss it more. This is less for you than it is for Senator Simpson and others. And lastly, let me point out.
You're right, Mads.
You point out that you say that, for example,
it's more he's taking a crack at Clarence Thomas because, you know, he's a constitutionalist as well, and he's very straight and down the line in terms of interpretation of those rights and that they should be inalienable. I found a nice little article on it that someone's done. I'm going to have a look at that in a minute.
Must be in the Constitution, liberty. Well, you know liberty means different things to different people. It's in the 14th Amendment. Now, some people interpret liberty in terms of natural law, as you well know. Some people interpret it only in terms of tradition and history. And some people, when they look at history and tradition, interpret it a different way. Scalia says when you look at tradition, you got to look at it very narrowly. Others say you look at it broadly. So it makes a big difference. It's going to be impossible to communicate to the people. My job is not to communicate to the people at this point. My job is to make sure that we know what your basic philosophic point of view is relative to the Constitution. I am not a detractor. Asking you these questions is not meant in any way, I hope you understand, to be a detraction or distraction. It is tantamount to understanding how you approach constitutional interpretation.
And it's off the grand finals between Fractal and Eric, our number one.
Hang on, where are we? Someone did a nice little article back in 2021 that I'll bring around. I'll bring that up here. I haven't had a chance to read the whole way through this, so I don't know if I agree with this individual or not, but it's a review of natural law 30 years on. The natural law 30 years later, Clarence Thomas's constitutionalism. Functioning constitutionalism that protects the people's rights and fosters good governance requires a sound political theory behind it. Times have changed since the American founding, but Thomas is right that the natural law teaching in the founders' political theory remains as sound and useful as ever. Now, do you need Hill hearings? Maybe another day. It moved on to some sort of grand final of Tetris by the looks of it. No, the Constitution is not an ever-changing government document. Promoters of the originalist theory of constitutional interpretation are at a crossroads. Many Americans, in particular religious and social conservatives, are questioning the ability of originalism and textualism to yield good results. They also doubt the sincerity of federal judges who claim to adhere to these philosophies, and of politicians who campaign on confirming those judges. The problem was magnified last year by Justice Neil Gorsuch's majority opinion in Bostock v. Clayton County, Georgia, which expanded protections under Title VII of the Civil Rights Act of '64 to include gay and transgender persons. Senator Josh Hawley summed up well the reaction of many conservatives. This decision represents the end of the conservative legal movement, or the conservative legal project as we know it. After Bostock, that effort, as it has existed up to now, is over. I say this because if you can take contextualism and originalism in order to reach such a decision, an outcome that fundamentally changes the scope and meaning and application of statutory law, that textualism and originalism and all of those phrases don't mean much at all. The crisis is ever more urgent with Dobbs and Jackson, the biggest abortion case since Casey on the Supreme Court's docket. So this is prior to that being overturned. The Constitution changing fundamentally almost requires a war. Blah, 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 Joe Biden. But that article is of newer date, right? It is ideas developed long after Thomas's confirmation years. Yes, this was dated in 2021. So this is prior to Dobbs being on the docket. No, it was on the docket, it just hadn't been decided, obviously. So this is, 2 years ago? It's looking back on the... I mean, it's, 30 years since he was confirmed, so... shit, where was I? Much of today's originalism is little different from positivism, which rejects the relationship between law and morality. Some of its greatest advocates have come to prioritize procedure over principle, loving law itself more than the justice that it's meant to protect. Some have called for a replacement theory like common good constitutionalism. The trouble is, without a coherent conception of what the common good is in relation to the Constitution, such an approach would be nothing more than a rule of the stronger power politics, like living constitutionalism. Others argue that originalism can be saved by infusing it with a proper understanding of the common good. Still others think that originalism is fine, but conservatism lacks the institutional infrastructure to combat the left. But before we attempt to develop any new theories, why not take a look at whom we already have? Last month marked the 30th anniversary of Justice Clarence Thomas's confirmation to the Supreme Court. 3 decades later, the hearing's discussion of the natural law thing, as Joe Biden called it, remains as relevant as ever, especially for originalism. Thomas's approach to constitutionalism restores the morality of law, which has been discarded by both positivist originalists and living constitutionalists alike, but at the same time avoids creating a new theory. Good morning, Munchkins. Stay there. Be right back, guys. Sorry, guys. Parenting always comes first. Alright. Anything in chat that I missed? Don't think so. Shit, where did I get to? Last month marked the 30th anniversary of Justice Clarence Thomas' confirmation to the Supreme Court. 3 decades later, the hearing's discussion of the natural law thing, as Joe Biden called it, remains as relevant as ever, especially to originalism. Thomas's approach to constitutionalism restores the morality of law, which has been discarded by both positive originalists and living constitutionalists alike, but at the same time avoids creating a new theory out of the whole cloth. Although his statements about the natural law were not comprehensive, given the limitations of the hearing format, Thomas made 3 clear points that can guide our approach to constitutional interpretation today. First, by natural law, or what he sometimes calls higher law, Thomas refers to a broader political philosophy articulated during the founding. My interest in the whole area of natural law was as a political philosophy. My interest was in reassessing and demonstrating a sense that we understood what our founding fathers were thinking when they used phrases such as all men are created equal, and what that meant for our form of government. Talk of natural law evokes many different philosophies and theories, but when Thomas uses the phrase, he has something very particular in mind, as he told in his memoir, My Grandfather's Son. I led my staffers, especially Ken Masugi and John Marini, in discussion of the natural law philosophy with which the Declaration of Independence, America's first founding document, is permeated. All men are created equal, Thomas Jefferson had written in 1776. They are endowed by the Creator with certain unalienable rights. That's natural law in a nutshell. If all men are created equal, then no man can own another man, and we can only be governed by our consent. I hope the Sov Sits don't get a hold of that. Just saying. Thomas's point is simple. The Constitution and the laws promulgated under it presume a common set of moral principles grounded in the political theory of the founding, which was best expressed in the Declaration of Independence. The equality principle, rightly understood, is the focal point of that theory, which leads to consent, natural rights, and the separation of powers. When Americans hear natural law today, they likely think of Catholic moral teaching, which is especially on abortion and sex. Academics might think of Cicero, St. Thomas Aquinas, or new natural lawyers. But Thomas isn't evoking any of these traditions directly. For Thomas, at least in the American context, the natural law is nothing more than an acknowledgement that the framework of the Constitution depends on the principles of the Declaration, and therefore must be interpreted in light of them. As a result of one of his primary intellectual influences, Harry Jaffa, wrote in How I Think About the American Revolution. The idea of equality, as expressed in the Declaration, is the key of the morality of the laws of nature and of nature's God. It is the natural law which the Constitution and the regime of the Constitution is a feature, is designed to implement. Okay. All men are not created equal. Proof, look at the tune in the show. Share at the tune. Basically. Second, Thomas clarifies how natural law should and should not influence a judge's interpretive work. I don't see a role for the use of natural law in constitutional adjudication. That's what I was saying. Exclusion of natural law. So basically what he's saying is that it needs to be interpreted based on exactly what's in the document as opposed to taking into account current societal values. Because societal values are subject to change and are almost always able to be pulled in one direction or another. My interest in exploring natural law and natural rights was purely in the context of political theory. The judge must not use his authority to advance personal public policy preferences. Impartiality. At the time of his hearings, liberal critics of Thomas's natural law views feared that he might use appeals to natural law to promote his own agenda, especially on the question of abortion. This, of course, mirrors the fear that conservatives in favour of judicial restraint had towards living constitutionalists. Thomas seeks to rule not on the basis of his understanding of natural law, but of the Constitution understood through its natural law foundation. Principles of natural law come into play only when what the text of the law or the Constitution requires is unclear for the case in question, or when broader consultation of the political theory driving the Constitution becomes necessary. For example, for Thomas, interpreting the straightforward text of the time, place, and manner clause, which stipulates guidelines for congressional elections, ordinarily does not require an appeal to natural law. Second Amendment interpretation, by contrast, is trickier. Common good constitutionalism calls the decision in District of Columbia and Heller supporting a constitutional right to own guns revolutionary. The only time the right to own a gun was revolutionary was during the Revolutionary War. We should all be equal, but some people should get more breaks. Some races can have cheap or free education, but others pay full price. Some should have more rights, not equality. But when Thomas considers the Second Amendment, he correctly identifies the right to keep and bear arms for self-defense as inalienable, and therefore interprets and applies the Second Amendment with this political theory in mind. Third, if natural law has no direct role to play in adjudication, what role should it play? Why would a judge need to understand its principles? Thomas answers that, although the principles of natural law do not appear explicitly in the Constitution, they were the justification for the Founders' whole project, as the Founders clearly state in the Declaration of Independence, State Constitution, and State Bills of Rights. Those and other public documents set forth the goal of limited government, grounded on a social compact based on equality, natural rights, and the consent to be governed. The Founders understood their project to follow necessarily from these principles, such that any law that is repugnant to them would be repugnant to the Constitution itself. Judges and ordinary citizens cannot possibly understand how to apply the Constitution without understanding the fundamental first principles that give it legitimacy. Thomas noted during the confirmation hearings that the Founders' natural law theory helps us understand why we should have a government that does not infringe on the rights of individuals, or a government by consent, rather than one in which our rights emanate from that government. It provides a sure protection of the rule of law against government force by will or ungrounded abstractions. As Thomas explained in his speech in 88, far from being a license for unlimited government and a roving judiciary, natural rights and higher law arguments are the best defence of liberty and of limited government. Moreover, without recourse to higher law, we abandon our best defence of a court that is active in defending the Constitution, but judicious in its restraint and moderation. Higher law is the only alternative to the willingness of both run-amok majorities and run-amok judges. Thomas's view of the natural law also provides transcendent standards for evaluating the goodness of particular actions of government. It does not direct government towards some vague notion of common good, whose content must be determined by the demands of the times. Rather, it entails specific rights and liberties which apply across all times and circumstances. That's exactly what I was saying earlier. The Founders understood their project to follow necessarily from natural law principles, such that any law is repugnant would be repugnant to the Constitution. Yeah. No arbitrary rule requires standards to guide and limit that rule. In the American context, those standards are most visibly provided by the Constitution. But Thomas thinks that our constitutional structures are unintelligible without a higher law to guide them, as he wrote in 87. Men cannot rule others by their consent unless their common humanity is understood in light of transcendent standards provided by the Declaration's laws of nature and of nature's God. Natural law provides a basis in human dignity by which we can judge whether human beings are just or unjust, noble or ignoble. Human dignity, natural equality, and other immutable truths do not change to suit the popular sentiments of the day. They are rooted in permanent natural order, the standards of which human reason can discern, and which the Founders articulated well. No worries, Tony. Yeah, that pretty well covers it. Okay, almost there. Good examples of Thomas's natural law approach are his recent Establishment Clause opinions. In his concurrence in Espinoza, Thomas rebukes a 73-year-old precedent exposing the faux equity principle that would prohibit states from expressing any preference preference for religion. A proper understanding of equality with respect to the Establishment Clause would allow for a robust and lively debate about the role of religion in government at the state and local level. Advocates for civic religion and virtue could freely make their case and attempt to influence public morals. By contrast, the court's jurisprudence of recent decades suggested that religion is dangerous and in need of policing. This stance has denigrated free exercise rights and those citizens who adhere to traditional moral standards. What effect a broader adoption of Thomas's approach might have is difficult to tell, especially because it seems unlikely that we could relearn principles of the founding generation anytime soon. Even in 1991, during Thomas's hearings, virtually no senators on either side of the aisle could articulate the role of natural law in understanding the Constitution, and very few commentators can today, let alone the public. By merely trying to do so, Thomas is an outlier. If you can't defend your own house, there's no equality in America. Perhaps the greatest utility in Thomas's approach lies in the potential for disruption. His commitment to separation of powers, coupled with his refusal to be hampered by stare decisis, could be the grounding needed to rein in the administrative state and correct the dysfunctions of the three branches of government. But what originalists and their opponents should bear in mind most of all is that a functioning constitutionalism that protects the rights of the people and fosters good governance requires a sound political theory behind it. Times have changed, but Thomas is right that the version of natural law expressed in the Declaration remains as sound and useful as ever. It is the primary resource needed for a sound judicial philosophy, much more so than the disputed notions of the common good, because it consists of the implicit morality behind the Constitution. Contrary to the views of legal positivists. The Constitution was made to implement the natural law of the Declaration. Any legitimate method of constitutional interpretation must be grounded in the Constitution's grounded in the Declaration's principles. They aren't as smart as Thomas, are they? Well, I think Biden really showed that during that hearing, didn't he? To be perfectly honest. So, well, that went off on a tangent. And then the other article is just a whole bunch of cases where it was decided by one vote or another.